Good sir.
But
Ma'am.
playing
Thank you, sir.
cricket,
Yes, sir.
bowling, batting, or all rounder.
Sir, essentially batting, but I'm working on my bowling also these days.
लेकिन एक बार आपकी अगर सर्विस लग गई तो ये हॉबी बड़ी अच्छी काम देगी। आजकल गांव-गांव में क्रिकेट खेलने लगे, गांव-गांव में पहले नहीं खेलते थे। अब तो गांव में बड़ी अच्छी टीम्स है, लगातार एक दूसरे खेलते भी हैं। चलो, आर्टिकल 32 ऑफ द कॉन्स्टिट्यूशन और आर्टिकल 226 ऑफ द कॉन्स्टिट्यूशन, क्या फर्क है दोनों का?
So basically, under Article 32 of the Constitution, the petition is made to the Supreme Court of India, whereas in Article 226, it can be made to the High Court. Article 226 is broader because in Article 32, it can be only for the enforcement of the fundamental rights, whereas in Article 226, it can also be issued for any other purpose also.
226 में कितनी तरह की रिट पिटीशन इश्यू करते हाई कोर्ट इश्यू कर सकता है?
So there are 5 types of writ petition that can be issued by the High Court under 226 of the Article 226 of the Constitution. These are, first is the writ of habeas corpus, second is the writ of certiorari, then it is writ of mandamus, then the writ of prohibition, and writ of quo warranto.
What's the writ of quo warranto?
So basically the literal meaning of quo warranto is by what authority. So it is issued to the public official that by what authority you are holding that position.
What?
By what, under which authority,
Yes.
and by what
Yes.
authority.
This is quo warranto.
Yes, sir.
What is the qualification for appointment of the Supreme Court judge?
Sir, firstly, to be appointed as judge of Supreme Court, that person must be a citizen of India. Secondly, he must have practiced as an advocate in the High Court for 10 years, and or he must have been a judge of the High Court for a term of 5 years.
What about one you are missing?
Yes, sir. Other is that he must be a distinguished jurist. Yes, sir.
Can you tell me anybody till day in the Supreme Court appointed as a distinguished jurist?
So till date, nobody has been appointed on the criteria of distinguished jurist.
Sure.
Yes, sir.
A money degree has been passed.
Money degree.
Money
Yes, sir.
Under Order 21, normally application of education writing होनी चाहिए. क्या मनी डिग्री के लिए एजुकेशन के लिए ओरल एप्लीकेशन हो सकती है?
Sir, if it is for payment of money, that oral
मनी डिग्री बोल रहे हो?
Yes, yeah. If it is a money degree, then oral application can be made. Basically, if the judgment creditor asks for the detention of the judgment creditor in the civil prison, then oral application can be made.
Whether the education of the money degree, if women can be arrested, sent to the property can be attained, she can be sent to the civil imprisonment.
For the purpose of money degree, women cannot be arrested and sent to the civil prison because it has been written in the CPC itself that women cannot be sent to the detention in civil prison for the enforcement of money degree.
You come here.
Yes, sir.
You purchase the property. Your property has been encroached upon by some other person without illegally. You file the suit. What nature of suit you will file for his dispossession?
So the suit will be for the recovery of movable property from that person. It will be filed under section 16 of the CPC.
Who is the appointing authority of district judge?
Who is appointing authority of
district judge?
I think it's High Court that appoints the district judge.
No. So governor of the state person on the recommendation of the High Court.
Noted, sir.
Now, who is the appointing authority? Your judge.
Sir, the Rajasthali State Judicial Academy, the exam is conducted by the High Court. And
who is the appointing authority? Conducting examination is the process.
I think it will also be the state government who will appoint us.
State government or governor?
Oh, yes, sir. Governor will
for both DJ or RJS. Difference is only that governor has to appointing authority, but there the recommendation, and he is after ये ना एग्जामिनेशन, पर्सनल एग्जामिनेशन। आप पूछिए पहले।
ये गिफ्ट क्या होती है, गिफ्ट की डेफिनेशन पीपी में?
Yes, ma'am. Gift is a voluntary delivery of any property to any other person. It can be movable or immovable, but it must be accepted by the other person. If it has not been accepted by the other person, then it would not be a gift. And at the same time, if no consideration is given when you give gift someone a property, then in lieu of giving that property, no consideration is received from that other person.
अच्छा, कोई प्रॉपर्टी ऐसी है जिसका आपने क्या किया, मतलब आपकी प्रॉपर्टी भी वो अटैच कर लिया,
Property as
किसी ने अटैच कर लिया और फिर आपने ट्रांसफर कर दिया अटैच होने के बाद, तो जो ट्रांसफर किया आपने किसी को फेल किया, जो भी एग्रीमेंट किया, तो वो क्या रहेगा, वैलिड रहेगा या वॉइड रहेगा?
वॉइड और वॉइडर, दे आर टू वर्ड्स, वॉइड और वॉइडर।
Sir,
आपकी प्रॉपर्टी अटैच हो गई, अटैचमेंट के बाद में आपने उसको ट्रांसफर कर दी, गिफ्ट कर दिया, सेल कर दिया,
sir,
मॉर्गेज कर दी, ट्रांसफर देना, सो मोड ऑफ द ट्रांसफर।
sir,
तो ये क्या वॉइडेबल होगा, वॉइड होगा ये? जो
sir, after attachment, I think it would be void. It would be void.
एक सीआरपीसी में एंटीसिपेटरी बेल है,
Yes, sir. Yes, sir.
तो वो किस टाइप के ऑफेंस में होती है एंटीसिपेटरी बेल?
Anticipatory bail can
What
only
type
be
of-
issued in non-bailable offences, and it can only be granted by the High Court in Court of Sessions only.
समरी प्रोसीजर जो है सीआरपीसी नहीं सीपीसी में,
हमने सूट
समरी सूट जो है वो कहाँ, कौन से आर्टिकल में है?
Ma'am, it is given in Order 37 of the CPC, in which the whole procedure of summary suit has been given.
और लिमिटेशन में कितने डेज का है इसमें एप्लीकेशन वगैरह लगाते हैं मिनिमम?
Sorry, ma'am, I didn't get the question.
लिमिटेशन एक्ट में पीछे जो दे रखा है
Schedule, yes, ma'am.
उसमें कितने डेज का है समरी सूट के लिए?
Sir, for filing reply,
फाइल द
Time.
सूट,
सूट के लिए
फाइल द सूट, व्हाट इज द लिमिटेशन फॉर फाइलिंग द
Limitation.
सूट इन द लिमिटेशन एक्ट शेड्यूल है पीछे?
yes, sir, I exactly, at the moment, I don't know that time duration which is given in the schedule for filing summary suit. I know the time limit for filing reply in summary suit, that is 10 days.
10 डेज है। सर आप पूछो।
देखिए, इनको स्टार्ट करने से पहले मैं आपको बता देता हूँ, आपका परफॉर्मेंस बहुत अच्छा है, आपका प्रिपरेशन बहुत अच्छी है, हमारे हिसाब से तो आप सिलेक्टेड है।
हाँ,
अब ये अब जरा गूगली बाउंसर सब कुछ आ सकते हैं और जो आप क्रिकेटर हो पता नहीं कुछ भी आ सकता है। मीडियम इंग्लिश,
Sir, my medium is English.
इंग्लिश में दिल्ली का पढ़ा हुआ बच्चा है।
ये फाइल से कंप्लेंट अगेंस्ट भी
Yes, sir.
in police station and police registers case under various sections. Some of them are valuable, cognizable, some of them are non-cognizable. After investigation, police puts up a challan, puts up a report, giving FR in the cases relating to cognizable offense, but recommends that these non-cognizable offences are made up. What option is left to the magistrate to deal with such a report?
Sir, whenever any report is given to the magistrate by a police officer, then magistrate is not bound by that report, whether it is closure report or charge sheet, because the report is given by executive mind, whereas judicial is a magistrate is a judicial mind. So even if no in non-cognizable cases report has not been given, still magistrate can take cognizance on those issues. It is totally discretion of the judicial magistrate.
Is it correct?
Sir, I think so that it is.
The magistrate can take cognizance on the report of the police,
Yes, sir.
on a report, or treating the report as a complaint. First,
Yes, sir. If it,
you
yes, yeah.
have missed this fact.
Yes, sir. I missed that question.
That
Sir.
the report submitted by police officer shall be treated as a complaint, and
Yes,
the
sir.
magistrate can take cognizance. This is what I wanted to judge.
Yes, sir.
Now tell me, is there any provision in CRPC which mandates the SHO that Before arresting a person, the accused shall be given notice. When and under what circumstances?
Sir, Section 41A of CRPC deals with it, in which the SHO, before arresting the person, can give notice that you can appear before him, before the SHO, and if that person complies with that notice, then no arrest is required. But if circumstances as such that even after the compliance of notice by the person, arrest is required, then police officer can arrest even after giving the notice.
Files a suit against me
Yes.
in the court of SDM. This suit is decided against me. He files appeal in the court of Revenue Appellate Authority. The judgment of SDM is reversed. He files second appeal in the court of in the Revenue Board, and the Revenue Board sets aside the judgment of the Revenue Appellate Authority, saying that second appeal does not lie here. The second appeal ought to have been filed in the High Court, as there was an issue which was decided by the Chief Judge on reference by the SDM. The appeal is delayed. The person comes before the High Court and the appeal is delayed. What remedy is there for him for filing the appeal with such a long delay? The appeal in Revenue Board has been decided in
Yes.
and he has covered it. What remedy is left to him?
So in this situation, the appellant can use Section 14 of the Limitation Act, whereas if he has been prosecuting the proceedings in good faith, then be it any court, that time will not be counted and that will be excluded from the original limitation period.
But what about Section 5?
So Section 5 only applies on appeal and application. Yes, sir. Section 5 can also. Yes, sir. Section
That
5.
is the main section.
Yes, sir. Section 5 will be
It would
used
be
under condemnation.
sufficient ground. You have pursued
Definitely, sir.
your remedy in the Revenue Board in good faith. Therefore, we will have to move application under Section 5 rather with Section 4.
Noted, sir.
क्वेश्चन ठीक था थोड़ा रेवेन्यू बोर्ड से आ गया ना थोड़ा
Yes.
थोड़ी सी
I missed that.
आपका क्या कि टेनेंसी लॉ आप लोग नहीं पढ़ते हो टेनेंसी लॉ नहीं पढ़ाते लाइसेंस टेनेंसी एनी अब पूछो
Anyhow, the question before is that a complaint is filed before the magistrate.
Yes, sir.
It is investigated against 5 persons. Challan is put up and report under Section 173 is put up under Section 173(2) against 3 persons, and 2 persons are let off. What remedy is left to the complainant in 2 situations? Number 1, if the matter is before the magistrate. Number 2, if the matter is before the session judge.
Sir, in this situation, Section 210 of the CRPC can be used, whereas if magistrate has taken cognizance even against one person, the whole of the suit against all of person can be tried by that magistrate. And sir, can you please repeat the second question because I didn't understand this.
Before the session judge.
Yes, sir. If the matter is before the sessions, then they can also take. They can also ask for, even if they can want, they can take the cognizance against those persons also against whom the report has not been filed.
Under what section?
Section.
Or the main intent. Here you must.
Yes.
As a general, you are not required to cite section. But this is the case. This is the case in which you are required to know the section, particular section under which you are required to deal with it.
Under Section 209.
390. 390.
319.
3-1 additional
That is
process.
section.
Noted, sir. Noted, sir.
How would he deal it?
Sir,
When will he take cognizance? What is required on the part of such a judge to take cognizance?
sir, cognizance can be taken upon the records that magistrate has in front of him. And if on perusal of that records, magistrate think that cognizance can be taken, then cognizance can be taken by the magistrate.
But he has committed only 3 persons.
Sir,
What about the remaining? Cognizance is to be taken against the, I'm talking with reference to the 2, not with reference to the 3.
Sir, I think,
Against whom cognizance has not been taken.
sir, I think those against those 2 persons also cognizance can be taken by the court of sessions.
But how? You have to tell me the procedure. How?
Sir, section 319 talks of additional prosecution, whereas if magistrate is of the view that all the persons who have not been charged in the suit, they have committed the crime for which they can be tried with the accused, then court can take additional prosecution against that person. Even though it's a trial is going on, still prosecution cognizance can be taken against those person. This is a mandate under section
What is the
319.
condition precedent for taking cognizance?
But you are missing that.
That is the main point you are missing.
But otherwise, ठीक है.
Everything is okay.
If
But the main thing is missing.
If magistrate think that accused,
मजिस्ट्रेट की वाली बात तो कर दी आपने.
मजिस्ट्रेट तो गया,
गया.
ऊपर गया, सेशन में गया वो तो.
sir,
Must record evidence.
Pre-charge.
Pre evidence record करके if is of the opinion. Let the 2 persons who have not been implemented as accused have committed the offence, cognizant offence, then the session judge can take cognizance against them by pleading them as an accused.
FR was taken a complaint.
noted, sir.
तो pre-charge evidence लेनी पड़ेगी बेटा.
Yes,
बहुत
sir.
अच्छा, बच्चे.
I understood, sir.
बहुत अच्छा. Wonderful.
Basic knowledge.
Very, very wonderful.
As a general rule is, we do advise the candidate that you are not required to cite the section.
Yes, sir.
There are certain
Unless, but second, maybe, unless they are especially asking, you are putting a question, give the reply. Therefore,
Okay, sir.
under this section, then only. Otherwise, you will miss, sometimes you miss the section also. What second?
Noted.
Sir?
A wants to file complaint for dishonoring of check
For dishonoring of check. Okay, sir.
against B. Check is drawn at X, loss for encashment at Y. How would you, where would you file the complaint?
Sir, I think it would depend on the type of check. If it is an account pay check, then the holder of the check, then the place where the holder of the check has account, that place is where the suit will be instituted. If it is otherwise in an account pay check, then at the drawer's place, the suit will be instituted.
The liability is when the check is in the name, it is accounts pay check.
If it is an account pay check, then the holder of the check will be the place where the proceeding will continue.
Where? At what place you should file the complaint?
At that
Where the check was drawn
no, sir.
or where the check was lodged?
Disorder.
No.
Huh?
If it is an account pay check, then if suppose A is a person who received the check, then it will be filed at that place where the person is holding his account. If he is holding his account at B place, then suit will be instituted at that place.
Is there any difference? Any difference has been pointed out in NI Act that what type of check should be? There is no such difference.
Account paid is
It can be any type of check, accounts payee or
non-account paid
non-account payee or a saving account check.
or current account.
They settled on now. Previously it was a fluid situation.
Yes, sir.
Is that wherever the check has been lodged, the complaint should be filed there.
Noted, sir. But I think it is settled now.
Yes.
Yeah.
Just it has been amended also.
बाद में
Amendment भी हो गया.
वो ठीक भी, वो ठीक
Tell
है,
me,
ठीक
what are the necessary ingredients for your success in this case?
In
है. 138
138 का
130 कंप्लेंट में सक्सेस के लिए
आपकी सक्सेस के लिए क्या जरूरी है?
लास्ट क्वेश्चन
Firstly-
लास्ट क्वेश्चन
Firstly, that check must have been drawn for the purpose of paying any debt or any other liability. That person must have submitted that check in the bank within its validity, and that check has been dishonored by the bank, and that person has given notice to the other person that within a period of 1 month that the check has been dishonored, and that the drawer of the check fails to pay the money to the check holder within a period of 15 days. Then the cause of action arises in the section 138 of the NIA.
थोड़ा सा
सर
एक बहुत बेसिक इंग्रेडिएंट आप भी बताते हैं
Yes, sir.
थोड़ा बहुत इम्पोर्टेंट
two basic ingredients.
बहुत इम्पोर्टेंट
Number one, that the check dishonored should have been drawn by the accused.
Yes, sir.
दैट इज मोस्ट इम्पोर्टेंट
Most important.
And second is that the complainant must be holding such a course in due course. He should be a holder in due course.
Yes, sir.
When these two necessary
These are
ingredients
the
are,
most important.
rest are formalities,
They are all procedural.
Yes, sir.
procedural formalities.
Basic
Notice must have been
to
given.
constitute the offense. These are two the basic. बाकी the procedural है.
Noted, sir. Noted.
Last verse. Are there any presumptions in favor of the check?
Yes, sir. There is one presumption is that if a check has been drawn, then it is drawn for the purpose of paying any debt or the liability. And if the check has been dishonored, then and any bank memo has been produced, then it will be a presumption that the check has been dishonored by the bank. These are the two presumptions that can be taken in respect of a check.
What is the other main presumption you are missing?
So can I take a moment?
Section 118 says that if any check is issued, it shall be presumed to have been issued for due consideration.
और वो भी consider
Consideration.
Yes, sir,
Section
I missed
118
this point.
says there are many other 6 presumptions. One of the most important presumption is that it has been issued for consideration.
बहुत अच्छा भी वंडरफुल
That works. You are good.
बहुत आपका हमारे साथ कलेक्शन होना चाहिए आपका
Thank you.
अच्छा अगर अच्छा बहुत आपका एवरीथिंग अच्छा आपका क्वेश्चन भी बहुत अच्छा है जो आप पहली बार आए जो स्टेट हॉस्टलिटी गया बहुत वंडरफुल बेस्ट ऑफ लक
Thank you, sir.
अब सिलेक्शन वाली आपको हो गया तो आप हमारे लिए क्या करो
आप ये बेसिक
So definitely I will come to.
नहीं बात करोगे क्या
ये बेसिक चीज थी जिनको लोग मिसिंग करते हैं ये दे जंप लेकिन उसकी पहली शर्त ये है कि ही शुड बी होल्डर इन ड्यू कोर्स
So I will keep this in mind.
बेसिक इंग्रेडिएंट्स होते हैं ऑफेंस होते हैं हर सच के
Yes,
इंग्रेडिएंट्स
sir. I
तो
missed
इसलिए
that.
आपको अगर मान जाओ
अच्छा आप कह देंगे दिस क्वेश्चन है
एवरीबॉडी कोई बात है सबको उनको समझा देना तो
So,
आप कब सिलेक्शन हो गया तो 3 डब्बे मिठाई के
बिल्कुल
ले
सर.
जाना
No,
हमको तो आप
without
हैं, और उनको
बिना-
लिख जाना ये साहब के लिए इनको तो लेकर पहुंच जाएगा तो मैडम तो लेकर पहुंच जाएगा तो वहां ध्यान रखिए बेटा